So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being. I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail.
So here we are again, not even a full week after his last court appearance. And this guy's already back in front of the same judge. February 19th, caught stealing liquor from a Norway Quick Stop. Yep, you heard that right. He was just released on bond days ago and somehow thought, you know what? Let's go grab some free booze. I mean, you can't make this stuff up. Now, before the judge can even finish rolling through the case file, this guy jumps in with one of the wildest sovereign citizen rants you'll ever hear. He starts claiming he's an American non-citizen national and that his name is copyrighted. Apparently, that means the court can't legally hold him in jail. He even throws in some...
All right, people of the state of Michigan versus Drew James Peltola, files 247831SM and file 247819SM. Mr. Peltola appears from the Dickinson County Jail. Counsel
appellation known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living.
Random legal case, something about Railroad versus Tompkins, as if quoting case law is going to magically erase his theft charge. Here's the thing. Sovereign citizens love this kind of word salad. They believe if they copyright their name, they somehow own it. And that means the government can't use it against them in legal paperwork. Basically, they think it's a loophole to opt out of reality. Courts have debunked this nonsense over and over again, but they just keep trying it. It's like arguing gravity doesn't apply to you because you disagree with it. The judge, to his credit, tries to stay patient. He lets him ramble about copyrights and living beings, but you can practically see the irritation building on his face. Then the judge calmly explains that, yeah, his comments are noted, but that doesn't change the fact that he's facing new charges. And honestly, I can't...
All right, is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off the drugs and try to maintain my court dates.
All right. In regard to the matter, then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, that your objections in respect to the court's jurisdiction and whatnot are noted for the record. All right. Concerning the matter, then, I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case. Total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond concerning the new theft case. Then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney.
Can't blame the judge. You give this guy a break, and less than a week later, he's right back, drunk, stealing, and talking nonsense about sovereignty. So now the judge starts laying it out. This man was arrested just 2 weeks earlier for being drunk in public, with a blood alcohol level of 0.236. He got a break, he got bond, and he promised to do better. Instead, he went out, violated that bond, and stacked up another charge on top. And now the judge's patience is clearly wearing thin. But hold on. This hearing is about to take a turn that'll make you wonder if the system's being too soft here. When it comes time to set bond, the judge actually goes through this guy's history, and it's long. 2 felony cases pending in Wisconsin: narcotics, drug paraphernalia, concealed weapon, bail jumping.
If
in residency, he lives in Wisconsin.
in residency, no, he lives in Vulcan, or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My residency and my domicile is 1968 River Street. We can switch it with a mailing address to W43, the apartment 13 in Vulcan, Michigan. The address should be in there. It should be bracketed.
Right, and that's apartment 13. You didn't put that on there though. Apartment 13?
Yes, ma'am.
And that's your mailing address though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got two issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your mother's house is, Mr. Peltola.
Nine
Ma'am.
address.
River Street, Niagara, Wisconsin, 54151. My mailing address will be W45. That's the Norway, the Vulcan address. I can't remember that off the top of my head.
All right. So in regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. I'm going to set that at 1,000 cash surety, 10%. In regard to the newest bond violation, then I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at 2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in
Can I say
custody,
something?
she'll be in touch with you. You may.
Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under.
You name it. The man's record reads like a bad resume. Despite that, the judge once again decides to give him a chance. He sets new bond conditions. No alcohol, no drugs, stay away from bars, stay away from the quick stop, all the usual stuff. Now here's where I'm scratching my head. Why isn't this judge throwing the book at him? This guy's been warned, arrested, released, violated, and now he's back in court pulling the same stunt. He's not just breaking laws. He's flat out rejecting the entire idea of accountability. Letting him out again feels like asking for trouble. It's like handing car keys to someone who just...
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your...
Can I at least tell you, admit I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence. Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
Crashed into your mailbox and saying, "Try again, maybe you'll do better this time." And just when you think he's done, he goes right back into his Sovereign Citizen Act. He claims the court has illegally kidnapped him. Seriously. He starts demanding the judge admit, on record, that he's being unlawfully held. At that point, you can tell the judge is done. He shuts it down immediately and orders him back to jail. But here's the thing. The bond is still set low enough that he could get out again. And that's what really gets me. Because what do you think a guy like this is going to do the second he walks free? Learn his lesson? Of course not. He'll be right back out there claiming he's a living being who doesn't have to follow the law. At some point, mercy stops being compassion. It starts being a mistake. People like this don't just challenge the system. They make a mockery of it. They shout about their rights while breaking every rule that protects those rights in the first place. Maybe the judge is trying to be fair, maybe trying to give him one last chance. But how many chances does it take before it becomes absurd? So what do you think? Should this guy have been held without bond this time, or do you think the judge was right to show restraint? Let me know your thoughts, because from where I'm sitting, this man doesn't need another opportunity. He needs accountability,